Hello, everybody. Welcome to another session of Lunch and Learn with GEO. Today, we're going to talk about cyber privacy, security issues for lawyers, and how to take some protection. Because we're lawyers, I have to give out a disclaimer. Here's the obligatory disclaimer. It's the same one we do all the time, but we are recording. If you want to ask questions, use the Zoom chat box. If you got background noise or you're on the phone or anything else, make sure you're on mute. If you're going to post to social media, please use this hashtag. The next webinar is August 10th, how to use video at trial. And I'll give you instructions at the end of the webinar on how to get CLE credit. And then we're going to welcome today Dan Cotter, past president of the CBA. You probably see his articles, weekly column in the Chicago Daily Law Bulletin. Dan is a prolific writer and speaker, and we're blessed to have him today. In case you need reminding, you're here today because the Illinois Code of Professional Responsibility requires you to keep up with things, including the benefits and risks associated with relevant technology, which is extremely poignant here. And the ethics from the ABA amendment to Comment 8 require us to do that also. So with that, I'm going to stop sharing and invite Dan to share his screen.
Can you see it?
Yes, we're
There
good.
we go. Good. Well, thank you, GEO, and thanks to everybody for coming. For some of you may have been on before Memorial Day. I was up in Wisconsin, and one of the risks of technology, as I was talking to GEO ahead of the session, is making sure that you have the actual technology and ability to provide services to your clients, as well as be able to make presentations like this. And one of the things GEO and I talked about afterwards, and I still have to get, but I should have a Verizon hotspot. My phone's a hotspot, but you should have a Verizon hotspot or some kind of hotspot so that you can access your stuff on the road. We'll talk about some of that down the line. Disclaimer, same as GEO's, to general advice. We're not giving legal advice. I'm not your lawyer. We're going to not really spend much time on the history and looking back. The slides are in here, they're in the chat as well. But we're just going to kind of, just a reminder of how far we've come. If you've been a lawyer for 5, 10, 15, 20 years, the practice of law substantially changed in that period of time, no matter what period of time you've been practicing. And again, as GEO said, the comment 8, and we'll get into, talks about the benefits and risks of technology, including being able to advise your clients on some of the ramifications of posting and doing certain things in social media. But it also, given the landscape that's changed, the ways in which hackers are being resourceful, we've got the metaverse and all kinds of other crap going on. And so it's increasingly complex for us to be able to understand what in the heck we need to do to be sure that we're protecting our firm and our clients, their valuable information. So again, these are, I'm just going to leave these up here. You can take a look at these at your leisure.
By the way, the PowerPoint is in the chat box. You could download it from the chat box.
Yeah. And one thing that I think I mentioned last time, and that I always take a look at, is Rule 34A1A was amended in 2006. That's not a typo, but that's when this actually went into effect. And again, anybody who litigates, for those of you on the webinar that litigate, this substantially changed the way that practice was done, right? It's the electronically stored information was added. This is a small amendment, but this led to e-discovery and relativity and all the other stuff that we now deal with in litigation, that prior to that was questionable whether or not electronically stored information was part and parcel of discovery. One of the things that I've done in my past career, I was in-house for many years, As I did a lot of record retention, we had major discussions internally about this because emails the way that we do business now, we store everything electronically. And so if you have a record retention policy at your firm, you should have consistency between what's online and what's in boxes stored outside or elsewhere. And again, just a lot of these slides, it's a lot of the different technologies that are out there. And again, it has ramifications for how we conduct our practices. Again, the numbers are crazy in terms of the hacking. The hackers have become more and more resourceful. They're very sophisticated, but if you look at this 15-year period, more than 1.7 billion records that were stolen in that period. The ITRC no longer tracks on a going back to 2005. They said it was too difficult to kind of come up with numbers. Again, so why do we as lawyers care? If you look at the news, and some of these are older, but if you look at the current news, it continues day by day. As GEO mentioned before we got started, one lawyer has noted the settlement agreement, the orders, everything said written check, and someone spoofed his email address, and it's unclear to this day whether or not that email was actually accessed, or because the notices, the class actions and everything else have email addresses, it changed where how the money was to be delivered. We have a case right now for one of our clients. That's a small bank in Central Illinois. Their outside accountants had their laptop in their car that was locked allegedly. That bag also for this young accountant. The bag not only had the laptop in it, but it had the password and the encryption key. And so one of the things we'll talk about that all of us as lawyers should be doing is encrypting our hard drives on the laptop so that if it's taken out, it can't be accessed unless you have the encryption key. The problem with this laptop is that the bag contained the password and the encryption key. The other thing that's we're investigating is it sounds like that accounting firm allowed their people to save locally on the local drive. And so even without having access, you can do a cable and pull the data, and there may be some significant personal information of the bank customers on the laptop. And so more to come on that, but you see stuff, there's a laptop stolen from law offices of David Krause. From several years ago, it happens. We, at a prior firm I was at, we had one of our attorneys left her laptop in the back of a taxi. Thankfully, no access was had, and the ability to wipe it was there. But again, these things happen. You know, folks use thumb drives that aren't encrypted, all these things, and so we'll talk about some of that. A few years ago, it was discovered in the last couple of months, but over the last several years, Operation Cuckoo Bees was the massive Chinese stuff. They have been on many computers for a period of years, hovering out there and accessing things, including with law firms. And why are we worried? Again, some initial thoughts, and then we'll get into some of the rules, and then we'll get into some of the practical aspects of what this looks like. One of the things that we always make clear is that the comments and the competency that GEO talked about at the beginning in the introduction doesn't require that we become an IT professional. In fact, it'll probably not be a good use of our time. But one of the things that I can't emphasize enough is that you need to have a strong IT team. You should not be skimping on IT or on cyber insurance or other protections. But the one area where you might be vulnerable if you don't spend the money is in IT. But again, you don't need to be an expert. It's dangerous. We should stick to our knitting. But what we should know and have an awareness of, again, is what risks are presented by the various technologies that keep expanding, and what can we do to make sure that we have protections in place with strong passwords, with encrypted hard drives and other things. So we'll dive into these some more, but there's a number of rules. GEO talked about Rule 1.1 of competence. We'll revisit it. Rule 1.6 talks about confidentiality of information. Illinois Rule 1.4 is communication. We've got duty to safeguard client property. 115 and 116 property includes, of course, intangible property like data that we have from our clients. And then there's duty of supervision that comes into play because if we run a law firm, whether we have assistants or associates or peers or colleagues, we all are in this together. We're all responsible as a team to make sure that we're following that 1.1 competency and that we're taking care of our clients' needs and goods. And she already talked about the Illinois Rule 1.1. He already presented it to you. It includes competence in selecting and using technology. And if we don't have the necessary technical competency, again, bring in that qualified team. That team could include family members. I mean, if you have young kids, or she was talking about his nephew, you could have younger attorneys that have a competency. But again, at the end of the day, you should have somebody that's wise in IT, that knows the lay of the land. And at least at the beginning, and as you set up your systems or on a regular basis, you should be taking care to make sure that you do in fact have those things.
Like pretty went crazy. This thing printed at least twice.
And again, here's comment 8. We have to keep abreast of changes in the law and its practice, including the benefits and risks associated with relevant technology. And again, what does that mean? It doesn't mean we're experts, but it means that we have to, again, understand some of this stuff. Many of you may be getting calls from clients that are in crypto or in non-fungible tokens or the metaverse, or you name it. Just some examples of how technology keeps exploding, whatever the new social media platforms are, the challenges of that, depending on your practice and what your clients are doing out on social media, accessing or friending judges and things of that nature that again come into play. And so you need to understand the benefits and risks. The benefits, I think, are pretty clear, right? In technology, the reality is we have, all of us have a cell phone that has more information, all the information the world's ever created, that's searchable within 10 seconds. There's trade-offs on that, and we're not going to talk about that much here, but the trade-off in life is, if you talk to people about their privacy and concerns about being hacked, and the letters they get periodically from various credit cards or other agencies that notify them of potential breaches, they say they're concerned about privacy. They want to rein in privacy. Some of the states are starting to come out with laws such as California, Connecticut, Utah, and other states. We have BIPA in Illinois. But when you talk about that, they say, yeah, I'm concerned about my privacy and my information, and I worry about it being leaked or stolen and being held up for ransomware. But what's the alternative? It would be to unplug from the grid, and that's not a realistic proposition for any of us, I don't think. It'd be very difficult to really operate in the current environment in the 21st century without having these tools. The risks are a bit more challenging, right? Because again, we don't know what we don't know about these technologies. And so we have to think carefully about that. Whether you practice in Illinois or you practice somewhere else, all 50 states in the District of Columbia have adopted the ADA Model Rule 1.1, either in whole or with modifications. As some of you that might have licenses in multiple jurisdictions know, there are some minor and some major differences amongst the states in terms of how they incorporate the model rules of professional conduct. At least 36 states have adopted the Common 8 that talks about the risks and benefits of technology. One of the things as well is that we practice in Florida. In September 2016, the Supreme Court of Florida mandated that every lawyer has to take 3 hours of technology-related CLE in a 3-year cycle. And when you look at the justification for that, again, it has to do with what we talked about already, this explosive growth and constant change of what technology looks like and the tools available. And the only other state, to my knowledge, that's adopted that is North Carolina. And I think it's a good idea. You know, we have at Illinois, we have a lot of different requirements for mental health and diversity and other things now. Maybe technology will come to Illinois sometime in the future. And again, I'm not going to go through these. You can come up with your own, but there's again, just shows the complexity. You can come up with the ABCs of cyber. So, why is any of this relevant, and why does the 1.1, the competency, have an impact when it comes to privacy and cyber? And it has to do with Illinois Rule 1.6E. Again, we have to take reasonable efforts to prevent the inadvertent or unauthorized disclosure of or unauthorized access to information relating to the representation of the client. And so what does that mean? Again, the ABA, and we'll talk about some of those things, reasonable efforts is really not solidly defined. When I was at a prior firm, the general counsel of the firm would always complain that the model rules are aspirational, they're kind of generic. They don't really get into great detail. And, you know, like any professionals, I passed the CPA exam. You look at the model rules and requirements for certified public accountants, very similar, right? They're broad aspirational. So what does reasonable efforts mean? It's on a case-by-case basis, depending on the nature of the technology of your clients and the information being provided. And we'll talk about this a little more later, but there have been rulings by the ABA and the comments to this Illinois Rule 1.6. It says that you don't have to use special security measures if the communication supports reasonable expectation of privacy. Over the last several years, a number of state courts and bar associations have issued opinions on this. Again, it has to do with whether you have to encrypt emails when you send them. And again, the comparison that's made with emails is that there should be the same expectation of privacy when transmitting to our clients as if we were sending something to the U.S. Postal Service in an envelope, right? We don't expect that to be ripped open. And again, you have to take special steps, or you have to consider the nature of the information being transmitted. The best practices are, if it's sensitive information, you want to encrypt it or have some kind of system in place, again, so that the ability to hack is not heightened. You don't want to have situations where you are facing, in fact, potential malpractice claims and client discontent. Again, special circumstances may warrant special precautions. So if you're sending HIPAA-related information, social security numbers, health information, other information is considered sensitive, you're going to want to take special precautions. And then, notwithstanding whether or not any special heightened duty is required, one of the things you have to keep in mind is that the client controls. And this comment 19 makes it very clear that a client may require that the lawyer implements special security measures. Again, acting competently with strict confidentiality, it's all tied together in terms of this understanding the technology and making sure you have in place good systems. As mentioned, a client can require a lawyer to implement special security measures, not required by the rule. And sometimes they do. You know, if you represent banks or insurance companies, oftentimes in their engagement letter, they are very clear in terms of what they want you to do with respect to any data that's transmitted back and forth between them. They may have a special TLS line or other encryption measures. They may use a special Dropbox type of thing, OneDrive or other links that are secure, or they may give you a secure portal. The example I gave earlier of the bank, that the laptop was stolen from the outside accountant, all of our communications, they sent me the notice from the accounting firm and everything else. It's all via a secure link, and you have to go into that email and verify yourself. Again, they don't want that information to get out and have a double hack occur. This opinion is all, but one of the things again that we don't have to take is ultra supreme levels of protection to make sure that our emails and our correspondence with our clients is not protected. In this case, this lawyer did a bunch of stuff. The lawyer encrypted his files. He installed several layers of password protection. He randomly generated what the folder names and passwords were. We converted each document to a PDF format that required a password again. And what the Arizona bar said was, in satisfying the duty to take reasonable security precautions, lawyers should consider firewalls, password protection schemes, encryption, antivirus measures, etc. But they did concede, and again, all the formal opinions, whether it's from the ISBA or the ABA or any other state bars opinions, they all talk about this. Again, we're not guarantors that we're not going to be hacked. All of you have heard the saying that it's not a matter of if, but when. The reality is that the hackers are going to keep trying. Lawyers are a rich source. Why is that? When you think about some of the hacks that have taken place over the last several years, there was the Macau Chinese nationals that were going to Wild Gotcho and other firms in New York for press releases on transactions, then trading, insider trading on that information that was released ahead of time. If you're a plaintiff's lawyer, we talked about with the case GEO mentioned, the class action settlements, right? There's big money at stake. If you're a real estate attorney, the biggest cause of malpractice, the biggest filing of claims for malpractice in Illinois, in most states these days, is real estate closings. And it's very similar to that check situation. In Illinois, if it's over $50,000, you can no longer bring a check to closing. You have to do it by wire transfer, real estate closings. And so what happens oftentimes is that these hackers are looking at and searching the internet for law firms that do a lot of commercial and residential real estate. And then what happens is a couple of days before closing, they spoof the email. It's very easy to spoof emails. And what does spoofing email mean? It would look like it came from me, dac@h2law.com, going to the bank, right, and saying, hey, or from the client, hey, I've changed the account that JP Morgan that I wanted to transfer the money for, to put an escrow for the buyer, and you get to closing on a Friday afternoon. You're all ready to settle, papers all signed, and then you call the bank and they say we already transferred the money, and lo and behold, instant malpractice claim because it's gone.
Hey, Dan, I had I was talking to a consultant about the spoofing issue that I was mentioned before. There's a standard of care that you have, because of all this spoofing and hacking that's going on, before you send a check that you got directions for in an email, you should call that person directly, speak to them, and confirm how they want that check to go to. In fact, the bank is doing that with me now. If I send an email to the bank saying I need this, I need that, the banker calls up and gets verbal instructions from me. So the standard of care has changed about how you issue checks.
Absolutely, or wires even. One of the things that my colleagues and when I've had situations where we have a wire coming is I always talk to the client, I talk to the bank, right, that's getting the wire, and we say, you know, you have to get a verbal and call to confirm with the person, right? You can't just get instructions via an email. You should be getting it via fax or via PDF that's password protected. But like you said, GEO, the standard of care in these cases is that because it's so common that these things are happening, everybody in all parts of the transaction, law firms should have a policy in place that they talk to their banks, they talk to their clients, say, look, I'm never going to email you wire instructions, right? I'm going to do it this way, and it has to be a confirmation process. Otherwise, we end up again. I've known many lawyers that have shown up to closings. I've had many people call me and say, what the hell can I do? I'm the buyer and now my money's gone. My $250,000 to buy my house, my greenhouse is gone. And not a good situation. You know, it's, you know, get the FBI involved, maybe they can get the money back. But these things, again, these hackers are exceptionally talented and they're also elusive. And one of the things that reminds me, when I was in house in the late 1990s, I worked for CNA Financial, and we would start new divisions and stuff all the time, and we would do press releases. And one of the things that they did not do was these to secure URLs or to secure the name with the USPTO or anything. And then there were hackers back in those days that would would then buy the URL and then they would send a ransom letter. And this is before the piracy laws went into effect. And when we threaten them, they'd say, you can come try to find me, but all it is a relay router in Vegas. You have no idea where the hell in the world I'm at. And so similar here, very hard to get the money back once it's out the door. Again, the rules have a bunch of stuff about safeguarding information. And one of the things that I think is a challenge for us as lawyers is that like a lot of laws, a lot of codes, this stuff really hasn't kept up with the times, because it's what they do is they just kind of shoehorn in with the comment, like comment 8 to 1.1. They don't really consider how the practice law has changed over the last 25 or 30 years with respect to, again, everything's electronic and digital. So 115A says the lawyer shall hold property of clients with third persons that's in a lawyer's possession in connection with the representation separate from the lawyer's own property. Other property shall be identified as such and appropriately safeguarded. And again, it doesn't talk about your systems and your drives and all that stuff, but all that information is property of your client. And again, you have to keep that protected. So the ABA in the last several years is trying to keep up, as well as the state. ISBA has done a very good job, and in many cases has been at the forefront of some of these opinions on cloud computing and other things we'll talk about in a minute. But in 2017, the ABA came out with formal opinion 477, and it's talked again about this transmission of information that we talked about, that you don't have to take extraordinary security measures unless the client requests it. And what the ABA confirmed that states like Illinois and others had already decided several years ago was that unencrypted emails are generally okay, so you don't have to do anything to protect them when you send them in transmission or at rest. But again, special circumstances or laws may require it. Think about like the California Consumer Protection Act that talks about sensitive information and data and how you protect it, GDPR. The Biometric Information Privacy Act of Illinois, they all have standards. And again, you may have to make sure that your communications and your clients' implementation technology may require special circumstances. And again, it comes back to this reasonable efforts. It's a balancing test. It looks at the size of the firm, the complexity of the type of transactions. It looks at the type of information being conveyed. It includes again that a lawyer generally may transmit information related to representation of a client over the internet, whereas undertaking reasonable efforts. Again, that pretty much is what it says. Did it change the landscape? In some ways, it may have a little bit, but again, the reality is that we should have been paying attention to this, given that we need to protect the information. And so what your lawyers do to address, again, should keep in mind whether or not you need to do special precautions. One of the things I talk about in light of this often is that one of the things it talks about is whether people have access to emails. And so many firms, small firms, when I was in a small firm, we used Google email, Gmail for a while. And if you ever are on Gmail, Yahoo, MSN, ads pop up. They do have bots that kind of look at the data, and then you'll see stuff that's related sometimes to your emails. The challenge, and what I always recommended back when we were using Google Suites, was that I would advise clients that were using that thing, that it was possible that, again, Google for quality control and other purposes may have used or may have accessed emails, but they're not looking at the content. The reality, though, is for many of us, I don't know what all of your practices are, but I imagine GEO and many others, when you do plaintiff's work, when you do corporate work as well, like I do, many of the emails that are being used by our clients are, in fact, these kind of generic emails, right? And so, again, we usually have a conversation about that if they're using Yahoo or Gmail. The other area where you see this a lot, and we've talked to ADR providers, many ADR providers. We've hired judges, we've hired litigants. They use Yahoo and other things. And again, we need to make sure we're thinking about that as we convey information to them. Finally, on this, the one special circumstances that comes up, and oftentimes if you represent employees in employment disputes or employees in other matters, one of the things you should be advising them if you see an email that comes from their work address is that they have no expectations of privacy there. And so they should be using their personal email address or another email address that they established to be able to communicate with you. If you don't do that, you could, subject them to issues as well as your advice and counsel to those clients.
Dan, that's a very important point. And I don't think people understand it. If there's somebody working for a company and they're using the company email address, there's absolutely no right to privacy by that employee to any of its emails.
Right. Yeah. And so if you're communicating with them and you continue to communicate, your emails probably are not protected either, right? So you're advising them, if there's an employment dispute or some other, whatever the issue is. So even if it's a personal data, they shouldn't be using their work address, right? Because again, they may have gotten it in a personal injury, there may be worker comp issue complications, or maybe other issues that has nothing to do with employment related. And so it gets to be an issue. So we always, if we see that, we will always advise them, give them a call, not email it back, but talk to them.
We just tell them to get a new email for personal use.
Right. And most people have one. I mean, there's not many people these days that don't have their own personal emails. The ABA, after they talked about the encrypted emails, they talked about our obligations after an electronic data breach or cyber attack. The opinions available there. And this duty comes under the auspices of us being required to keep clients informed about matters. And so again, one of the things that GEO was talking about, that case with the check for the settlement company, there's a related or an ancillary issue where there was a spreadsheet that was attached to a communication, and now there's concern about whether or not that information was accessed or what's going on. So again, those are difficult conversations. And again, you don't want to be one of the lawyers that has to call your clients and tell them that you may have had a breach, mid-sized, big firm, small firm. You may all recall a few years ago, Johnson & Bell was accused of not patching and not keeping up on a lawsuit, and they ended up being vindicated, and then they sued the firm that had sued them. But again, it's not a good PR to have to go to your clients and say, I think our systems have been hacked. And the reasons why are because we didn't install patches or do other things.
And then a big hole in your practice is your staff.
Right.
If your staff has to be constantly admonished, and I mean constantly admonished, not to open anything that looks suspicious. We're getting fake faxes, all kinds of things. If they don't recognize it, we tell them do not open it. In fact, delete it. If it's that important, they'll resend it to us. But do not take any chances. Just don't open anything suspicious.
Yeah, I had a conversation at a conference once with a guy who was investigating years ago. I don't know if you remember, but some people would send like little roosters or things, animated stuff at the bottom of an email, and again, people would click on those, and then it would do some more movement and stuff, and those were just full of malicious malware, and they were trying to trace who the employee is. I mean, one of the things to that point, Gio, is not only good communications and good policies in place with your staff, whoever works on things, to make sure that they understand the risks of this technology and these spoofing things, but to test it sometimes. And at my firm, for example, they'll send out emails that look like they might be legit, just to see what the reaction is, because somebody should be identifying it and saying, you know what, this is, I hovered over the email and it was not who they said they were, or, why am I getting an email from HR or IT? And so training, reiterating, and making sure, like GEO said, if it looks suspicious, you can, in exchange, you can report things. More and more, I look at things and I report them. And the worst case is that if it was legit, someone will call me or send me another email. But if it looks suspicious to me, if it doesn't look like it's, if it has typos, if it looks like it's poor grammar, it gets tossed out. So. And again, 483 talked about employing reasonable efforts to monitor technology and the office resources connected to the internet. We had a client recently, they're doing a shared space. It's not WeWork, so one of those, but the lease had language in it that said, look, the internet that's being provided to all of our clients is a shared internet, and there's no privacy. And so one of the things that I told my client is you have to get a hotspot or get your own internet, because it may be free built into your rent, but that's a recipe for disaster. And they're in the staffing business, so they're gonna have a lot of personal data, background checks and things, just insane. You have to not be an IT expert, but you have to be able to look out for risk. And 483 is a reminder that, hey, you better understand all the technologies you're using at your firm and make sure that you have protection. So again, you're not in the news, you're not making a malpractice claim.
I want to add something here. I never use a public Wi-Fi like Starbucks or anything else like that. And I don't even use a Wi-Fi like in federal court. I don't use the court's Wi-Fi. I bring my own hotspots, especially when we've got multiple lawyers representing, like the plaintiffs, a group of lawyers. I bring a separate hotspot into that courtroom just for our communication, so that there's no risk that our communications while we're in court and we're discussing strategy and ideas get hacked by the other side. It's just scary what could be hacked in a public Wi-Fi.
It is. We'll talk about an opinion on that in a minute. But back in 95, which is a long time ago, again, if you have people coming in for computer maintenance, again, you have an obligation to make sure that there's protection. So just like you would with papers on the desk or anything else, people can't come in when they're cleaning. Again, if you have a breach because some maintenance person came in and screwed something up or steals data, you have that responsibility. And then there's termination of representation, duty to supervise, we already talked about. So we'll kind of just roll through these. Rule 1.4, we already talked about. You may have to warn your client about the risk of using electronic communications where a third party may gain access. This is the employee thing that we talked about. This is the Google and other things. One of the things that these formal opinions talk about in the ADA, formal opinions very old, is that you may be required to recommend to the client methods of ensuring that electronic communications remain confidential. Like GEO said, maybe that's if they don't have a personal email address they can access, that you make sure that they create one for purposes of communicating with you. There's duties to former clients. There's all kinds of other laws that we may have obligations that are not specific to lawyers, but that do govern, and it's an emerging group of laws, including 5, 6 that have very strong privacy laws, but more coming in the near future. So let's take a look at some of these things. We've talked about emails kind of already. You don't have to encrypt them, but again, it's good to do. Your trash. One of the things, again, we're focused on technology here in cyber, but one of the examples I give in recent times, as GEO said, I write weekly for the Chicago Daily Law Bulletin, is this whole leak of the Dobbs decision back in April or May, and now we're finding out from Joan Biscuit that there may have been other leaks, and this may have been left by Roberts. But in any event, one of the things that I think it was Michael Lee, who was a clerk at the Supreme Court, said was back when he was there. They had shred bags and they did double and triple shredding, but they also had burn bags so that the draft were burnt, and so nothing left the building. Not that you have to do that in your office, but again, you don't know who the janitorial staff is or who's coming through your office, who has access to your office after hours during your working hours. You should be very careful about your trash. Most firms have some kind of a locked garbage can or something to ensure that, again, data is not being stolen.
I have an anecdote here. On one case we had, an Illinois state senator from downstate had the practice of having all of his emails printed on yellow paper. And then he would write comments on that and give it back to his secretary to do that. And we had a dumpster dive came up with his emails that we got some really good information from.
Yeah, it happens all the time, and there's a case from a few years ago where, again, a case that had resolved, and the lawyer put his boxes in the dumpster after the period of retention, and somebody found those copy machines. One of the pictures that we glided over at the beginning several years ago out of New Jersey. The CBS reporter went out to a warehouse, and one of the printers that was from a health provider still had the image. So all copy machines that you rent or own, they make images of everything that's copied on those things or scanned. And so lo and behold, there was 450,000 or so health records and individuals that were implicated there. There was reports that the reporter knew that these copy machines were there, but it was a great expose, and that healthcare provider paid millions of dollars in settlement and fines and penalties for having breached. Other things like working in a coffee shop, your workspace at home, portable data storage devices. The one thing I when I did training at a prior firm I was at, I said that thumb drives and going to the hotel, that the computers that you plug those thumb drives in, even at Costco, right? You take pictures and then you go with your thumb drive and you get your things printed. What I compared thumb drives to in the computer USB ports is to bathrooms, the road stop bathrooms. You don't know who's been there or what they left behind. It's the same thing with the portals and USB ports. Be very careful if you take thumb drives on the road, putting those in to print your boarding pass or do whatever you're doing, because again, a lot of malware exists on those machines intentionally. I already talked about the laptop of the vendor stolen from the locked car earlier. Having a password and encryption key in the bag or a sticky note on top of your computer is just a recipe. Even in your physical office, again, you never know as tight of controls as you have. I've been at firms, I've been at clients where, you know, the receptionist goes to the bathroom or something, the door's propped open, whatever the case may be. If people can get in, they can start looking and taking stuff. And again, you don't want that to be your situation. So trash and recycling, you should shred everything that's privileged or confidential. When in doubt or when you don't know, shred. And again, you don't need burn bags, but you should have a shred container or your recycling bin. You know, this shouldn't be put into the custodian's garbage bag at night, because again, as GEO said, people are going to go dumpster diving, right? If you know your opposing counsel is in a certain building, you can go to the dumpsters, and again, you never know what you're going to find. You don't want to, you know, leave kernels for the other side. Even your office and your files, and I'm the worst at this. You know, my desk is always a loaded mess. But you should be taking care to lock those things down. Again, depending on who comes in the office, what's taking place. I've done audits of small and mid-sized law firms where we kind of go in and just talk about their policies and procedures in place, as well as take a physical walk around. At one, that's a very prominent toxic tort claim firm. I was in a conference room, and the boxes all had names on them. Boxes that have tops on them. I didn't look in, but again, somebody could be a witness, could be opposing counsel. alone in those rooms. Again, you don't want that information to be out there. You're just as responsible for that in physical form.
Just think about your passwords. How many of you write down your passwords on a little note next to your computer? I mean, come on. That's not doing it anymore. I put a link in the chat box for a software program called LastPass. At least use that, something like that will save your passwords and give somebody else, like in your family, access to them if something happens to you, so that if you keel over tonight, all of your information is retrievable by using LastPass and having the master pass to it.
I agree that can't emphasize that enough. So Geo talked about he never uses the Wi-Fi at Starbucks. This also relates to hotels and things. It used to be back in the day when you were a gold member or something of like the Hilton or whatever, the honors level, they would give you a password at the front desk that not everybody had. Two things on this: at Starbucks, at hotels, at the airport, that you should keep in mind is, again, one is that those systems might be out, other people, they're public, other people might be able to see them. Worse off than that is that one of the things that happens increasingly at these hotels and other places is that folks are spoofing and putting up. So when you look at your network of open networks, it might look like it's Starbucks, but it's not Starbucks. It's somebody else's personal, private, kind of spoof of a Starbucks site. And again, there's things called Pineapple Technologies for $99 or $100. They can follow every keystroke once they've got you in their system, and then can have your passwords. And once they get your passwords, even if you have encrypted data, even if you've taken protections and done all the other stuff, they can get into your system. And once they're in, they can explore, and then they're off to the races, right? It's like a burglar coming into someone's house and having the luxury of no alarm or anything, and having hours and hours to go through the multiple rooms and find what they're looking for. But this opinion, again, it's older. It's been affirmed by other state bars. GEO doesn't use at Starbucks. I don't as well, other than for very basic stuff on my personal emails occasionally. But all the formal opinions say you can probably do it if you take appropriate steps. And one of those appropriate steps, again, what are you looking at when you're in there? You shouldn't be looking at sensitive data or your client information. You shouldn't be pulling it up, doing a brief or looking at their personal social security numbers or stuff, or class action, whatever it is. You need to think and keep in mind those things. And again, as Geo said, the technology and the hotspots are not super expensive anymore. And so you're best off to have a hotspot with you if you're on the road or at the Starbucks if you're going to use access. There's questions in the same opinion. They talk about Wi-Fi at home. Again, in this new post-pandemic or in the pandemic era, many more people are working from home. And again, if you have internet at home and you're using it, that's fine. But you better have a good router password. You better have good access passwords to your internet, so that someone driving by or coming to your house can't access it. You also need to be careful, and this happens all the time, is many families, I'm presenting today from my firm's laptop. I don't have a personal laptop anymore, but many lawyers allow their families and their kids to go on the system. Again, what kind of protections do you have in place so that if they're on there gaming or looking at a Disney movie or something, that you're not giving access to your family to data that's client protected. The again, portable electronic storage devices, its duties of confidentiality and confidence. You should have password protection on each of the files in there, as well as a master password, so that again, somebody can't just take a thumb drive or CD and put it in and look at all the things that you put together. You want to think about what's in your hard drive, and again, are you storing locally, or are you storing to some kind of cloud? And one of the things that we as lawyers probably don't do a very good job at is we don't do good record retention policies, right? And we keep drafts and drafts and drafts of stuff. So some of this from a cleanup perspective and from a protection of your client's data, we should be thinking about those things as well. When a client terminates, when the case settles, what are we doing to archive that data so that it's still not out there and available? So lots come up with the cloud. And again, the ISBA has been a leader in this. You can use cloud. So one of the arguments I've made from years and years of working in insurance companies and other things, there's always been what's known as the cloud, because a lot of data centers, I worked at a company, Unitron, now Kemper, a corporation insurance company, and their servers were in Oak Brook. We were downtown Chicago. That's cloud computing. The difference in cloud computing these days is that we're all using shared drives. We're using vendors like AWS and others. But again, when you look at these opinions, including the ISBA ethics opinion, what it says about this is like any vendor that you would use, you need to take reasonable steps. And if you're using AWS, if you're using Google, if you're using some of these services that are reputable, well-established, and have insurance, it's probably okay. If you're using Acme Cloud computing services, probably might have some issues, right? Because again, are you taking reasonable steps to understand the benefits and risks of that technology, and do they have the bells and whistles and security that the larger, more formidable vendors have? So yeah, again, ISBA came out their opinion. They focused on 1.1 competency and 116E. Did the attorney act reasonably competently? It always comes down to that. And so again, if you went to your brother's cloud computing and you're his first client and only client, then again, maybe you weren't reasonable and competent in selection. So a couple of things on law firm policies that you should have. One is an incident response plan. What is an incident response plan? It says if you're breached, if there's a breach incident, is it HIPAA related? Is it personal injury, personal information? Is it HIPAA related? And how you have to respond in accordance with state laws, in accordance with the 1.4, informing your clients. Is there anything that you have to talk to your clients about the breach? And so you should have a good incident response plan. You already talked about password policies and having a centralized password. You should not be taking this to your computer or on your desk on a notepad. One of the things I'll say about password policies as well is that we're 30-something years into people having emails and everything, 40 years almost. And when you look at every year, the most common passwords, there's still password 1234. Law office. I mean, come up with something that's better than that. The best advice that's out now, it used to be that you would come up with these nonsensical things where you change an E to a 3 and you couldn't remember it because it was 22 digits. The thing that people are that are hard to penetrate and hard to attack are phrases, right? Come up with something that's a sentence or a phrase that may be nonsensical. Maybe something personal to you, but it's going to be very hard for someone to come up with all 25 digits. You should occasionally consider doing a security risk analysis to see if you have good things like patch implementation. So one of the things that happens with Exchange, and one of the when we find these big breaches that get reported, like at WannaCry and some of these other big breaches that have taken place, what happens is that these software vendors and primarily the email servers like the Exchange, they send out to your IT vendor or your IT team or whomever's doing it patches and say, you can probably get that if you have an iPhone, right? You can update to iOS 15.6 tonight. You need to make sure that you're implementing those patches, because many of these patches are designed to address what the hackers have been doing. And in many cases, when you see some of these breaches that have occurred, it's because the IT has not implemented, they're not up to date on patching, and so you want to make sure that you have that in place. You should consider designation of a security official. And who is this person? It's someone that, again, if there's a breach or an incident, they're the person that's going to look into it and deal with your IT team to figure out what the solution is. Workstation use and device and media controls. again, you should have all kinds of policies so that, as we talked about, now notice and continued conversations with your staff at all levels to make sure that they're not falling for these things. One of the things that's very common, and again, because everybody posts on social media and you get out of office messages, sometimes hackers will send an email. They'll get an email back from the chief financial officer of your law firm saying that I'm out on vacation for the next 22 days. In the event of an emergency, contact so and so. And one of the things we're seeing more and more of is vendors and other things spoofing, saying, "Hey, this is Dan, CFO of the law firm. I instructed while I'm out to transfer $1 million to XYZ vendor."
Hey, Danny,
Yeah.
we're kind of running out of time, but the last thing I was going to point out is cyber insurance. Go back to that for a second.
Yeah.
I think everybody should check with their malpractice carrier and with your general liability carrier to see what kind of coverage you have in case you've been hacked.
Yeah.
Not all policies included, but you might want to make sure that you're paying a little extra for some protection in case you're hacked.
I agree.
I added, there's a lot of us are working remotely. What is now, you can't even call it remotely, it's now for all practical purposes, we're in a virtual practice. And the ABA has issued a model opinion 498. I put it in the chat box. There's now special rules that are being adopted for virtual and remote practices. So please be aware of these rules. And Dan, do you have anything else you want to close with?
No, I think that's again. I think having good policies, starting with passwords and knowledge of your team, gets you a long way. Like Geo said, you should check your malpractice insurance. You should consider cyber. Most malpractice policies these days have an exclusion making it clear that there's no cyber coverage under them. But back before that, there was always debate about whether it was actually the provision of legal services when the breach occurred, and whether you could shoehorn that into professional services. And as Geo mentioned, recently, ABA 495 and ABA 498. 495 has to do with this remote working virtual practice, the unauthorized practice of law. People move to Montana and other states, and there's all questions about whether or not you're practicing unauthorized. You can make sure of that. And then 498, as Geo said, talks about violations by remote practice. And like you said, it's not really remote anymore, it's virtual. So.
Danny, thank you very much.
You're welcome.
And you want to unshare?
Yeah.
And let me close out here with this reminder. If you want CLE credits, send an email with the subject line, "Thank you, NWSBA," to attendance@nwsba.org, and include your full name and your ARDC number. And the next session we have is August 10th about using video at trial, different forms of video. So with that, I'm going to stop sharing, and I muted some of you, and I'm going to stop recording.